And welcome to the Legal Lounge on CRN Digital Talk Radio, CRNTalk.com, streaming live coast to coast and around the world on CRNTalk.com, also in stunning high-definition video on CRNTalk.com, also on Facebook.com/CRNTalk. As always, I am joined by the one and the only. He's a practicing attorney, a noted author, a scientist, a constitutional scholar, Corvette aficionado, and semi-professional conga player, Mr. Richard Nixon. Sir, how are you?
Not too bad. How about you, Mike?
I'm doing very well. Thank you so much for asking. I appreciate it. And Richard, we both you and I during our pregame before we do the show here, we were talking about the week's current events, and we saw President Biden's speech in Dearborn, Michigan. I know
Yes.
Dearborn, Michigan is a place that's close to your heart. What were your thoughts on his remarks?
Well, it's interesting. I'll never forget that when I took a speech class in which I did fairly well, we were taught to distinguish between delivery and content. So again, I'm finding myself giving Mr. Biden, President Biden, a 90 or 95 on his delivery. I find his voice and his inflection and so on favorable, pleasant. But he did have a quote that comes from his parent or father or grandfather. I'm paraphrasing now when I say, a job is more than a paycheck. It's dignity. And what struck me about that is that goes counter to what he's done by stopping the Keystone Pipeline and stopping all building on the wall. It seems to me that his actions don't square with his rhetoric. And that's a typical thing that politicians do. They preach one thing and do another.
And also, I mean, Richard, not only, he talks a lot about, it's more than a paycheck, it's dignity, but his policies, though, don't really reinforce that idea, like you said, about the Keystone Pipeline, as well as building the wall, which has eliminated many jobs, but also with these enhanced unemployment benefits. I mean, people don't need to go to work, right?
Absolutely. So it makes it worse for the small businesses who need workers now, but the small business now is competing with potential workers who probably receive as much from the government as they would get if they came and took a job.
Well, not only that, Richard, we've talked in previous shows about the dynamic analysis of economic growth. Right. And with President Biden's new tax plan, raising both estate taxes, corporate taxes, and capital gains taxes, that leaves less money in the ordinary citizen's pocket, and people are less likely to start businesses and create jobs.
Absolutely. I mean, it goes counter to everything that President Trump did. President Trump knew exactly what to do. The fact that you reduce taxes, no matter what kind of tax, including inflation, which is in fact a tax, if you can keep inflation down, that puts more money in the people's pockets, and they can either spend that,
save it,
invest it, or save it.
Yeah.
And so any one of those three things, other than burying it in your backyard or in one's backyard, puts the rest of the country to work, which is one reason why it's a good idea to do these things, quite frankly, for the wealthy individuals and prosperous businesses, because they have the money. They have the money that can be used to do just one of those three things. Now, let's face it, someone who doesn't have much money can't do much to help the economy.
Very well said. We got a big show today, guys. A lot to talk about. We're going to talk about the Fourth Amendment. We're going to be talking about liability protection for petroleum companies, and we're going to be talking about EMPs, folks. So stick around. We're here in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com, Facebook.com/CRNTalk. Stay with us. And we are back in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. And Richard, one thing that really vexed me last week was The mainstream media really going to sleep on this Colonial Pipeline hack.
Yes.
It had really, profound effects. Gasoline was cut off pretty much to the entire eastern seaboard. And this hack was based out of Russia by a group called DarkSide. We're going to get into that later. But this speaks to kind of our infrastructure's weakness about in certain attacks, be it hacking, but also EMPs. What is an EMP?
Well, from what I understand it's an electromagnetic pulse which can disable our electric grids, and therefore some people like Dr. Peter Pry, P-R-Y, he warns that there's too much emphasis now on switching from fossil fuels, if you will, to electric grids that are not protected. And he also claims that it's a relatively simple task to create what I think you found, Mike, or your staff found, that this thing is called a Faraday cage. And basically you enclose these our electric grids. It makes it impervious from someone doing what others have done to our Colonial Pipeline. But again, if we don't toughen that up, we stand ready for Russia, China, any one of our enemies to wipe us out where we won't have electricity. And people don't seem to realize, but we need electricity for our water, our food, our transportation. It's endless. And several months of that, if the bad guys can do that to us for a couple months, maybe 6 months, it can wipe out a sizable portion of this country.
And just, to clarify a little bit more about the electromagnetic pulse, what it does is it pretty much fries any circuit. It creates an electromagnetic field that pretty much will fry any electronic device unless it's protected, or unless it's A, completely powered down, or B, protected by a Faraday cage, which is a shielding of some sort around an electronic device or its circuit board. But I think Dr. Pride, he was speaking about kind of the evolving energy economy, where we're moving away we're moving towards a completely electrical power system, where not only is your electricity is in your home, but also it powers your car, it powers everything, and taking fossil fuels completely out of the loop here. And he thinks that's kind of dangerous, right?
Yes, and I think he makes a strong case. We have to, what we had in the Colonial Pipeline when it went down, I think it should have awakened many of us to the fact that we need to have a mixture of, let's call it diversity. The left is always talking about diversity. We've got to keep going with fossil fuels just in case all this rush toward everything being electrified doesn't work.
Yeah, I mean, we've seen certain states, and actually the city that I grew up in, they banned two-stroke engines, which power like lawnmowers and leaf blowers and
right?
whatnot. Yeah, because it's not green, but also these power generators as well. And it also speaks to the fact that and also, I think Dr. Pride was speaking to this too, that it encourages less self-reliance, because if you can't provide electricity for yourself through a generator or solar or anything like that, you're at the mercy of these utility companies.
Correct.
And Richard, the Colonial Pipeline and EMPs, this kind of speaks to something that's been on my mind recently. It seems like we're back in the Cold War. We saw with the Colonial Pipeline, where the DarkSide hacking group, which is kind of a vassal of the Russian state security apparatus. And Russia kind of has a policy with hackers inside their own borders that so long as they don't attack Mother Russia themselves, but the heathen devil West, that they're protected. You lived through the Cold War. Do you think we're in another Cold War right now?
Well, I do, and quite frankly, I'm sorry to say, I think we have exactly the wrong administration at this time. I'm sorry to say again that President Trump wasn't reelected because China and Russia. China would probably take Taiwan if we get weaker, and Russia will take the Ukraine. And I think we're talking about cutting the defense budget. We're going exactly the wrong way. They're testing Biden and what I consider his relative weakness. They wouldn't mess with Trump the way they're doing it with Mr. Biden. I'm sorry to say that, but we have the wrong administration at this time.
Well, and speaking of the Cold War, I mean, Ronald Reagan, great president, was considered, kind of the victor of the Cold War. And he did that through stimulus through defense spending, where he spent trillions of dollars on defense, which, not only bankrupted the Soviet Union as they tried to compete, but also created a lot of jobs. What are your thoughts that, maybe we should increase the defense budget?
Well, I think probably the defense budget is sufficient now, but I don't want to see it cut back. But to mention my old buddy Richard M. Nixon, he's one of the people who said that people used to talk about his being crazy. He'd be crazy enough to push the button, the nuclear button. And he said, no, that's what I want. I want people to think that if they mess with the United States, that's what they'll get. Biden appears to be too reasonable. He's already backing down on several fronts with Iran and so on. Again, he appears to most people to be a nice older gentleman who is reasonable, and you cannot be reasonable with China and Russia, and I thought by now we've learned that lesson. That's
interesting to make the comparison between Richard M. Nixon and President Trump, because President Trump, love him or hate him, he was kind of irascible.
Yes,
and I think that image of his irascibility was a deterrent towards North Korea and Iran and so forth, because just like Nixon, they didn't know what he was going to do, right?
Exactly.
So that's interesting. We talked a lot about the colonial pipeline and that hack. How should we retaliate, though? Should we retaliate?
Well, again, I'm not sure what we can do, except maybe it's time that we did it, as they say, tit for tat. I'm sure we've got smart enough people, if not here, in Israel anyway, that would tell us how to do this. Yeah. And we can, I think, if I'm not mistaken, Israel's already disabled a number of things in Iran. They've done it in the past. And that may be the kind of Cold War that you're talking about that we may have to do for a while.
Yeah, that's very well brought up, Richard. The Stuxnet virus, which was the joint Israeli and NSA project, which actually it's quite fascinating. If you guys ever want to read about it, there's a great book called 0 Days about it, where the Mossad and the NSA actually, what they did is they put some malicious code on a little flash drive, a thumb drive as it's known, and they actually just put it in the parking lot of this nuclear enrichment plant in Iran. And some unsuspecting Iranian scientist is like, oh, look at that. Maybe I wonder what's on this flash drive.
Yeah.
Took it into their office, plugged it into their computer, and just by doing that act, this Stuxnet virus ran rampant through this enrichment process, the facility, overdrove the turbines, and destroyed it without a shot fired in anger. So, maybe that's what we need. And so, the United States and Israel has the capacity. I just don't know if the Biden administration has the will.
That's exactly my point. We have the ability, I think, but does Mr. Biden have the will, or will he just choose to shake hands and pull the Chamberlain?
And the lesson there, folks, is that if you find a flash drive sitting on the ground, don't plug it into your computer, even if you might think there might be pictures of naked ladies in it. Be right back, you guys, in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. Stay with us. And we are back in the Legal Lounge. Thank you so much for joining us. Make sure to follow Richard on Twitter at Richard A. Nixon1, on Parlor, which is back at PRES37TH. And check out his fantastic book, America, An Illusion of Freedom, available where fine books are sold. And you can find all that information in the description if you're watching this video on YouTube. Richard, Fourth Amendment. Let's
Yes,
talk
sir.
about the Fourth Amendment. What is the Fourth Amendment?
Well, the Fourth Amendment is part of the first 10 amendments that were amended, if you will, in 1791, 2 years after the Constitution in the whole. I'm going to state what that says and quote it. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, what's interesting about that is it tells us what cannot be done, but it doesn't give us the remedy if it's violated. Again, now this was intended to address the federal government, not the states. So it's basically saying that the federal government can conduct searches and seizures, but they cannot be unreasonable. So that's the issue for the courts to grapple with all the time. But it turns out over the years, our Supreme Court, not Congress, but our Supreme Court, has grafted onto the Constitution, improperly in my mind, a number of exceptions to the Fourth Amendment, and one of which we talked about last week, which is the open view doctrine. This week we've got two new ones, the so-called Terry frisk, the so-called stop and frisk. And this is a situation where two police officers were alerted by a telephone that we had a white male and a black male who were apparently urinating in the bushes. And when the officers arrived, Mr. Brown and Mr. Barrett came into view. Barrett, the police officer, Barrett, who was one of the defendants, fit the description provided, and the defendant reached his hands down on his sides and reached his index finger into his right pocket. Brown complied with Winning's instructions, and Winning reached into Brown's pocket and found heroin and other things. Now, so what he did is he not only patted him down, which is what the stop and frisk permits, but he actually went into Mr. Brown's pocket, and there he found the heroin and some other things. And so the trial court agreed that he could be prosecuted for that. But when it was brought up to the Ninth Circuit reversed and remanded and said very briefly that the court in Terry versus Ohio emphasized that the sole justification for a protective frisk is the protection of the police officer and others nearby, and any such search must therefore be confined in scope to an intrusion reasonably designed to discover guns, knives, clubs, or other hidden instruments for an assault on the police officer. And since this police officer went far afield, he knew, I guess, fairly well that there was no assault on his body or threat to him, reached in to the defendant's pocket. A motion to suppress was brought, and the defendant won that motion.
So the search and seizure of that heroin and that drug paraphernalia was then excluded under the exclusionary rule, correct?
Exactly.
So, I mean, this speaks to, the stop and frisk was a big issue in New York City.
It was. That's right.
And so the Ninth Circuit is saying that unless the police officer is in fearful danger, what's known as the limited exploration of arms,
right,
to protect themselves, to see if anybody that the police is interacting with is armed, is okay, but you can't go inside someone's pocket.
Right. Well, you see, now you mentioned New York, and that's interesting because Giuliani was credited with cleaning up New York and making it essentially a safe city. He encouraged, during his administration, stop and frisk was in vogue. And it kept people off the streets that were walking on the street with different kinds of guns and weapons and so on. If they took the chance, they might be busted by the police. It's my understanding that subsequent to that, currently, for instance, stop and frisk is stopped.
Yeah.
There's no stop and frisk, and so literally guys can walk from one place to another with the gun in their pants, and if nobody stops them and finds them, that's fine.
We're going to talk.
And crime has gone up.
It has, indeed. Indeed, it has. So you guys stick around. We're going to talk more about the Fourth Amendment right after the break. We're in Legal Lounge, CRN Digital Talk Radio, crntalk.com. Stay with us. And we are back in the Legal Lounge, CRN Digital Talk Radio, crntalk.com, talking about the Fourth Amendment, about unreasonable search and seizure. And unreasonable in that clause is working pretty hard, just like due process of law, and the 14th Amendment's working pretty hard. And we talked about the stop and frisk Fourth Amendment exception, and how the Ninth Circuit pretty much said that unless the officer is searching for weapons that might injure his person,
yes,
that any evidence during the frisk will be excluded under the exclusionary rule. And there's something else that the Fourth Amendment speaks to, the community caretaking function. What's that all about?
Well, yes, we have a recent case, interestingly enough. This is by the U.S. Supreme Court, none other than Clarence Thomas and John Roberts, Alito, Kavanaugh, and so on. Basically, there is such a thing. I'll read the headline. That police officers' community caretaking functions, such as providing aid, is not an open-ended license to perform searches. In this particular case, and I'll just paraphrase it, husband and wife were disputing, having an argument somehow. Husband took a gun and put it on the kitchen table and said, "Honey, why don't you just shoot me and get it over with?" She was alarmed. She called the police, and she called people who would refer her to a psychiatrist. The police, in the meantime, when they came to the house, they confiscated his handgun, and he, of course, wanted it back, and he was being prosecuted for having this handgun, which wasn't licensed. But again, what this stands for, this is another court-made law, if you will, or rule, basically saying what I said in the heading, that when a police officer is doing what is called a community caretaking function, that is not a license for him to go ahead and perform a search without a warrant.
And we talked about this community caretaking function, I think maybe about 2 months ago, because there's another case in front of the Supreme Court where they actually confiscated somebody's firearms based on one of these community caretaking functions. And like you said, another exception to the Fourth Amendment made by the courts and not by the legislature. But also we talked about this too, Richard. I mean, how there's so many different avenues and how, you never know what's going to happen in any particular situation. Can the legislature really kind of write law that's going to be able to address all these different scenarios?
Well, I don't think it can, and I think that's why what you're getting at, Mike, is eventually the Supreme Court and the Congress of the United States are going to have to defer these kinds of situations to the states where it actually began. When we originally had 13 colonies, we didn't have a Bill of Rights and so on. The states, they were big boys. They could figure it out for themselves. They had their own rules. And they could very well decide whether they want people to have guns or not have guns. And in this particular case, whether they want the police officer to be able to come into a house and render aid. And by the way, he actually sees something which again impacts on what we saw last week about the open view doctrine. These theories all mesh together, and they become almost impossible for the average very intelligent lawyer to figure out what the law is, and yet we expect the policeman to do just that same thing. So I think maybe what you're hinting at, Mike, is this. We should just back up, and I think Justice Thomas would be on our side, and start doing all these things, allowing the states to make up these decisions on their own.
Well, let me ask you this. I'm throwing you a curveball here. Would this, and think about this under the auspices of the separation of powers.
Right.
What if the Supreme Court in their decision says, hey, we're going to kick this back to the states,
Right.
but here's maybe what the state legislature should maybe consider as amending or passing a law to remedy this? What if the actual Supreme Court, or any court for that matter, gives advice to a legislature to clear up some of these issues?
Well, that's where the word remand means. In other words, when they reverse and remand, that's just exactly it. The courts have already laid down what they consider the law to be, and they're basically sending it back to the lower court to take a factual finding to see if, in fact, that's what actually happened in this case. In other words, many times what the Supreme Court is faced with is insufficient factual basis. And so they're saying, this is what should have happened. We're sending this back to the court to retry this, to see, get the information on what was really happening factually, and then decide it based upon that. So that's why you'll find in many of these cases, for instance, this one says vacated and remanded. So it's not the last word. They're basically sending it back to whatever this would be the Ninth Circuit or whatever.
And what if, so they send it back for the insufficient factual basis?
Yes.
Let's say that, the Ninth Circuit or whoever gets their ducks in a row, can this case then be reheard by the Supreme Court?
Absolutely. And in fact, it's not limited to factual. In other words, I should say the Supreme Court would remand it if it also considered what the lower court did to be in error legally. That is to say, they applied the wrong statute, or they applied the wrong law, period. Or the court comes up with some kind of new rule that they've just invented, and now they want the lower court to start fashioning it and using it.
Well, also, like we talked about letting the states dictate this, because I think that was the founders' intent. What the Supreme Court often does is they try to apply their views to all 50 states and every community as well.
Absolutely.
And that one of our themes about this show and your book too is that removes community standards and also representational government.
Absolutely. And we've said, I don't know how many times, that the Founding Fathers intended the people of this country to run their own government. And when they created the Constitution, it was their intent that they would create a federal government, but they would limit this federal government to things that the founders, thought were national in character and required a uniform rule. Everything else was to be done state by state. And that's where we get the 10th Amendment. And the 10th Amendment basically says the power is not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. So what the Constitution is saying is, if we haven't given that power to the federal government does not have that power. That power continues to reside within the states, and every state can do what they want on their own. And normally what happens is states look to see what other states are doing, and which one is the most effective, and they emulate it.
Very well said.
Thank you.
Very nice. Okay, guys, coming back. Stay with us here in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com, Facebook.com/CRN Talk, American Illusion Freedom. Available on iTunes, Barnes & Noble, and on Amazon. And we are back in the Legal Lounge, CRN Digital Talk Radio, CRNTalk.com. We talked about the Fourth Amendment earlier. Now let's talk about the Second Amendment. It's been a while since the Supreme Court has spoken about Second Amendment gun rights issues. 2008 was the seminal D.C. versus Heller case, and 2010 was the McDonald case, which I believe was in Chicago. But now there's a case heading to the Supreme Court, the Beach case. What's this case all about, Richard?
Well, this case involves the fact that both the two cases that you cited, the Heller case from 2008 and the McDonald case in 2010, both were concerned with putting limits on gun ownership in the home. But there have been other people, Scanlon being one from the Ninth Circuit, who said, well, that's only talking about part of the Second Amendment, that's the keep part. What about the bearing part? Now, let me read the Second Amendment real fast. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Now, so it's two-pronged. You have a right to keep the arms and to bear the arms. And people like Justice O'Scanlan from the Ninth Circuit says that those two previous cases only talked about the keeping. That is, you can keep the gun in your house for self-defense. Other people like O'Scanlan are saying, no, with the Second Amendment, we enjoy some freedom to have our guns outside the home. And what this case is about, the Beach case, is to what extent will the Supreme Court decide how to deal with guns outside the court, outside the home, for self-defense. And it goes from one extreme to the other. Some people say that'll be the Wild Wild West back again, and others are saying, no, I think the Supreme Court will slap it down and not extend it at all. But I think what would be very helpful in this discussion is to see, I know there are many states, like Texas, I think it's one of them, where they do allow open carry. But again, maybe I'm speaking out of school here. Whether they allow concealed weapons, I'm not sure. And to what extent, and I think I know the answer to this, but to what extent have the people decided to go crazy and start shooting each other out in the streets because you've given them the right to keep and bear arms outside the home? I think first of all, most people don't take the opportunity to carry a gun even if they could. But I can also see situations where just in driver situations where one guy bumps another guy's fender and they get mad, and one guy has a gun, so he pulls it out and shoots the other guy. So I think the statistics would tell us that these states that do have more freedom to have guns outside the home don't have more crime, and in fact they have less. But again, I don't know that.
Well, I mean, also you speak to the dilemma, I think, that a lot of gun rights advocates and all Second Amendment people think as well. I mean, yeah, you don't want to have the Wild Wild West, but also I mean, we have a frequent guest on some of our programs, Steve Wilford, who it was in Texas, and he saw a mass shooting happening at a church, and he was carrying, and he actually neutralized the shooter and saving countless lives. But this case also speaks to the new conservative majority on the court.
Yes,
we have I believe a 6-3 conservative swing on the court right now, and I wonder what your thoughts are on whether or not we're going to see perhaps some new legislation, perhaps more like we talked about the Fourth Amendment, more leeway for the states to dictate their own firearms policies.
Well, that's what I'm hoping they would do. Now, again, if they did defer to the states and let the states decide what policy they would have regarding carrying guns outside the home for self-defense, we have to underline the word self-defense, because I don't think anyone is going to argue that we should be able to carry a gun just to carry one. It's got to pretty much be for self-defense. The other problem I have with that, though, is this, that how can we properly allow one person, like a marshal or a sheriff, dictate the limits of your Second Amendment rights? And that's exactly what has happened here. You have to submit an application for permission from some state official to see if you can carry that gun. Why should your Second Amendments be dependent upon this one government official? I don't think it should, and I think the courts will strike that down.
Should the Second Amendment be applied to the states?
Well, that's the other issue, and you and I have talked about that. I didn't like the idea that Scalia said that right off the bat. I don't think it should, like any other of the Bill of Rights. None of those Bill of Rights should be applied to the states. And as you read the Second Amendment, again, I'll read it. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And that's addressed to the federal government. It's basically saying to the federal government, you shall not limit the people's rights to keep and bear arms. It does not limit the states. By the very terms of the Constitution, the states are free to fashion whatever rules they want regarding keeping and bearing arms.
And that's the tension, I think, that we're going to see in this case, is because we have a conservative-leaning court, but also, the conservative judicial intelligentsia is more of an originalist, constructionalist perspective.
Yes, and I think some people have decided they've got to get these decisions in before the Democrats pack the court and reverse it.
Interesting. We're going to be looking at this case moving forward as well. It's got a lot of implications, for the Second Amendment and for any firearms rights activists around the country. So stick around, you guys. We're here in the Legal Lounge. We'll be right back right after the break to wrap things up. Stay with us. And we are back in the Legal Lounge. Thank you so much for joining us. As always, you can follow Richard on Twitter at RichardA.Nixon1 and check out his fantastic book, America, An Illusion of Freedom, available where fine books are sold. We talked about the Second Amendment in the last segment. And here in California, where they pretty much don't want anybody to have a firearm, there's what's known as the roster. The roster is a list of handguns that the state of California, and I emphasize the state of California, deems which are safe. And so that limits what kind of firearms one citizen can buy in California.
Yes.
And that's not even to speak about the assault weapons ban, which is a whole different show. But there's a new provision, the 3-for-1 provision. What is that?
Yes. Well, very, very briefly, a federal judge declined to dismiss a challenge to the state's removal of 3 grandfathered-in handguns from a roster of firearms that can be sold in California, finding that the rule infringes on the Second Amendment. Now, this Judge Dana M. Sabra, Dana, I don't know, I think that's a woman, in San Diego agreed in a 15-page ruling the following, very briefly. She says it is well established that public safety is a substantial government interest. That's fine. However, the court is not persuaded that there is a reasonable fit between the state's asserted objective and the 3-for-1 provisions, wrote Judge Sabra. Defendants offer no justification for why the statute requires the removal of 3 handguns for each new handgun added, instead of, for instance, a proportional 1-to-1.
Yeah, I mean, just for the listeners outside of California, the California draconian gun laws, they make sure that any handgun that's sold in California passes these arduous safety tests where, like, they drop it off a 3-story building and see if it fires or something like that, or drive over with a car, freeze it up, block of ice or something like that. And what they're saying is that for any new firearm to be added to the roster, then 3 existing firearms have to be taken off the roster. And not only, Richard, do I think that, the judge says it violates the Second Amendment, but also, I think the manufacturers of these firearms would have a good case too, because it's taking money out of their pockets by allowing their products to be sold here.
Yes, absolutely. And again, we get back into the same old thing that maybe this is where the situation does not belong, because we've got a federal judge deciding these things regarding a state, when it should be the state itself deciding things regarding handguns and so on. There's a number of situations that I find troubling, and that is the fact that the legislature would have attempted to undo something that's been grandfathered in. That's the whole point of something being grandfathered in, is that it's relatively safe, that no one will attack it in the future. And yet that's exactly what our legislature here in California is doing. And
this isn't, just to be clear, this isn't about confiscation. That they're not going to confiscate these three firearms that would be dropped from the roster. It's just they cannot be sold in California.
That's correct.
And that seems, I would be interested, maybe we can talk about this another time, about the interstate commerce applications of that as well, because they're limiting business into a particular state that might be legal in another state.
Yes. And one of the things that, again, what the so-called Unsafe Handgun Act requires new pistols to have a chamber load indicator, a magazine detachment mechanism, and a microstamp technology. Now, none of the old guns have that, and that's why these guns, the older guns, if you will, handguns, are, if you will, grandfathered in, which they should be. It's my understanding that anyone who's acquired a gun before 1989 in California, it's relatively safe from having to have it registered or confiscated by the police. Mm-hmm. Anything after that is questionable. But again, the new ones, I believe, have to have those 3 things before they're recognized by the legislature as being bona fide.
Interesting. All right, we're right out of time. Any last words?
One last word, and it's for those people out there who are still licking their wounds because of this latest election, undoing President Trump. I'm one of them. Comes from no other than Winston Churchill, who said, "Success is not final. Failure is not fatal. But it is the courage to control or to continue that counts."
See you guys next week.